I'm Justin Silverman of the New England First Amendment Coalition. Thank you for joining us for another round of open government lessons. During this class, you'll learn about police misconduct records and how you can access them under your state's public records law. During this round of classes, we'll be joined by an attorney to explain how the law works, as well as a local journalist who will share their experience requesting these police records. If you haven't already, please view our previous classes on public records, open meetings, and state court systems. The lessons they provide are all cumulative, starting you off with the basics and then gradually addressing more nuanced areas of law and journalism practice. The classes are state-specific and provide practical, step-by-step lessons you won't find anywhere else. You can find them all in our FOI guide at NEFAC.org and on our YouTube channel, 5 Freedoms. Before we begin, I want to recognize the Estate of Gloria Negri for its support of these classes. Gloria was a trailblazing journalist at the Boston Globe for more than 50 years. This program is part of her legacy of newsroom education and her lifelong commitment to local journalism. Thank you also to the Rhode Island Foundation and the New England Society of News Editors for their continued support. And a big thanks to you for taking the time today to learn more about how to keep government open and accountable in your state. Now, here's NEFAC's Emily Sweeney to introduce you to today's instructors.
Hey everybody, I'm Emily Sweeney from the Boston Globe, and I want to thank you for joining us for this latest round of open government lessons brought to you by the New England First Amendment Coalition. With us today is Gilles Bissonnette. He's the legal director at the ACLU of New Hampshire. He's litigated cases on police and government accountability, public records, and the First Amendment, and he's testified before the New Hampshire legislature on more than 100 bills impacting civil liberties. We also have Paul Kuno-Booth, who reports on health and equity for New Hampshire Public Radio. Paul previously worked at the Keene Sentinel, where he covered law enforcement and the courts. He's also written about policing and police misconduct for the Granite State News Collaborative. Paul and Gilles, thank you so much for being here. I really appreciate it.
Thank you.
My pleasure.
All right, Gilles, do you want to kick it off?
Sure. Thank you all so much for the opportunity to chat about police records and just where we are in New Hampshire, what tend to be the rules of the road, what are the standards, and just how to advocate for yourself when you make these requests. Because in many of those instances where you're seeking police misconduct records, I would argue that you're actually entitled to those documents. So knowing the law here, knowing your rights here, I think becomes so critical, especially when we're dealing with public officials like the police, that have the ability to detain, use lethal force. So, when there's serious misconduct, we think the public has a right to know that information. So I want to tell you a little bit about not just where we are now, but where we were. So we are actually in a much better place than we were for decades with respect to police misconduct records. Between 1993 and 2020, you could not get misconduct records of government officials in the state of New Hampshire. And it doesn't just include police. It's for all public officials for the most part in the state of New Hampshire. And it was really a problem in the state. Journalists couldn't do their work. Advocates like me, couldn't do their work, whether it's, trying to learn more about what police departments are doing or trying to build a potential piece of litigation. So it really had a dampening effect on transparency and accountability in the state of New Hampshire. We and a couple other advocates, including media outlets, by the way, including Union Leader, Seacoast News, decided that we need to try to undo that in a series of targeted lawsuits back in the late 20-teens, which I guess is a weird thing to say to some extent, around 2016, 2017, in part because the state Supreme Court had suggested that they may have made a mistake in a 1993 decision that deemed all police misconduct records and government misconduct records categorically secret. So the court in a 2016 case said, we might have made a mistake there. That might not have been the right decision, but it hasn't been litigated before us. So, we're going to set that aside. But, crafty litigators like us and like litigators for the media outlets saw that in the Supreme Court decision and thought, whoa, maybe there's an opportunity here to try to take down this 1993 regime that was really having a terrible impact on transparency in the state. So originally, basically what the law was, all police misconduct records or government misconduct records were viewed essentially as internal personnel practices and were viewed as categorically secret. And after we brought these series of cases, in 2020, the Supreme Court fortunately reversed and overruled its prior decision and created a new standard where individual misconduct records aren't actually internal personnel practices. Individual misconduct records instead are evaluated under an invasion of privacy test where there is a public interest analysis. That is to say, when you make a request for police disciplinary information, you may not get it in all cases, by the way. It doesn't mean it's categorically open. It just means there's a case-by-case approach where you assess in the individual case the public interest in disclosure, whether there are privacy interests in non-disclosure, and whether there actually might be some separate governmental interests in non-disclosure as well. And so that was really a monumental decision where now we have a balancing test, and we can use that balancing test to try to advocate in favor of the release of documents. And so once that decision came down, then the question ultimately became, like, how do you apply this balancing test? So the ACLU, media outlets, other advocacy groups started engaging in a targeted kind of litigation campaign to try to find really strong cases where intuitively it would seem like the balancing test favored disclosure, getting courts to agree with that analysis, and then creating favorable precedent that we could use, that press outlets could use, trying to get information in their particular cases. And I think that additional campaign has been reasonably successful as well. I think the courts generally have landed where if you're dealing with, like particularly on-duty misconduct from the police, and when the behavior that you're seeking isn't kind of personal, like the medical records of an officer, that type of thing, courts generally, I'm not going to say it necessarily in every case, but generally seem to be receptive to the notion that that information should be released. And it's not just, the public needs to know for the sake of the public needs to know. One of the things the court has recognized is that it's important for the public to be able to vet the integrity of these investigations, right? These internal investigations. That's how you create trust and confidence in law enforcement. This is good for the police at the end of the day, because then the public has the ability to know that, gosh, that police department did a pretty good job in those investigations. And I can just tell you, as someone that gets these documents, the police department often does like a pretty good job in these investigations. So I don't want to paint a completely negative picture here, because it's not true, but it's important for the public to know that, so the public can feel confident in their police department. One particular case that I think just everyone should know about is the Provenza decision, which is the first New Hampshire Supreme Court case using that balancing test. And what that case was about was a conflict between a police officer and a woman that police officer pulled over. And there was a conflict. This occurred in November of 2017. Officer Samuel Provenza was alleged by a woman to have engaged in excessive force following a motor vehicle stop. And there was a report done on this particular incident. And the report actually examined whether the incident was excessive or not. And so just some of the facts of the case, as alleged by the woman, Provenza pulled the woman, who was 5'2", weighed 115 pounds, out of her car. According to the woman, Provenza pulled her out of the car by her hair, which was in a ponytail, kneed her in the left leg, and then tossed her on the ground or around. The woman suffered a serious leg injury because of the encounter, which required surgery. And so when this report was issued, we just thought the public had a right to access it. And the Supreme Court agreed in evaluating this balancing test, saying, quote, that the public has a substantial interest in information about what its government is up to, as well as in knowing whether a government investigation is comprehensive and accurate. And I want to be clear that the court made this finding even where the report was not sustained. with respect to the allegations of misconduct. And to me, that is incredibly critical as well. I think you will often hear some say, well, if it's not sustained, the public has a diminished right of access to it. I do not agree at all with that premise. Even if it's not sustained, it might actually be more important, right, for the public to be able to evaluate the investigation, to assess whether or not it was done with integrity. And so I think that's a very powerful decision. It's a decision that you should all use if you ever get pushback with respect to police misconduct records. I mean, I could tell you that we generally have significant success getting these documents now. And so if there is pushback, it is something that I would like to know about, to be honest, because I'm happy to provide kind of off the record thoughts about how to approach those situations. I have very strong views about the need to release this information. So with that, I'll close my remarks. I just want to thank, the First Amendment Coalition, Emily and Paul, for the ability to speak about these issues.
Awesome. Hey, thanks so much, Jill. That was really great. Paul, do you want to line up your presentation?
So yeah, I'm Paul Kuno-Booth. I'm a reporter for New Hampshire Public Radio. As Emily mentioned, my current beat mostly focuses on health, but I've done a fair bit of reporting on police misconduct in previous roles. And so I thought I'd just kind of talk about some specific types of records that I've been able to use during that work that I've found helpful. And I'm going to breeze through some of these, but if anyone has questions on specific ones, happy to talk more later. So the first is the exculpatory evidence schedule. It's also known as the Lori list. I think this is pretty well known, but it's essentially a list of police officers who have something problematic on their record that could be, lying under oath. It could be excessive force. It could be various different things. It doesn't contain a lot of details, but it's a great jumping off point for further reporting, right? If you see an officer from your local police department on there, might be worth looking into that person further. This is available online at a state website. It's updated every quarter, so definitely worth keeping an eye on. Okay, so let's say, you have an officer you're interested in finding out more about. Maybe their name popped up on the Lori list. Maybe you got a tip that they engaged in some kind of misconduct. One of the first things I'm going to try and get in that situation are internal disciplinary records. This is a lot of what Gilles was just talking about that was basically secret for decades, and now we have some access to. These are records documenting allegations of misconduct against officers, as well as the way the department handles them and investigates them. These can be really useful because they, of course, contain the details of the alleged misconduct. This is an example from a story I did last year with the Keene Sentinel. And we had found out that a officer who had worked as a police chief in a couple local towns, his name appeared on that list I just discussed for excessive force. So we obviously said we need to find out what this guy did to get on the list. We filed a records request with the town of Winchester and got these records back. This is one of them. It's a notice of suspension from duty, and it explains that this officer slapped a person in the face while the person was in handcuffed. So a clearly unjustified assault on a person in his custody. He was suspended for it. So this is a great example of the importance of these records. The other thing I want to sort of touch on with this type of records is something Gilles mentioned. Just, it tells you something about the officer's conduct, but it's also about sort of the system around the officer. So how thoroughly did the department investigate? Did they really hold the officer accountable or sort of give them a pass? Did the same officer have previous complaints alleging similar misconduct, and how were those handled? In this case, for example, we actually were able to find documents showing that the town select board voted to reduce this individual's suspension from 10 days to 4 days. 3 years later, some of those same town officials promoted him to police chief. So in this story, we were able to say that, some of these people who clearly knew that he had been disciplined for excessive force decided to promote him to chief. And I think that's an important accountability story that goes beyond just like what one officer did. So those disciplinary records, really useful if you can get them. I have still run into resistance from some departments, and even when I don't, it can take months. So what do you do in the meantime? There are some other places you can go to try and learn some of that information. So one is the Police Standards and Training Council. This is the body that oversees and certifies every police officer in the state. They also have the power to decertify officers who engage in misconduct. Those proceedings are often, in public meeting minutes that are posted on the council's website. So if you're looking into an officer and they've been decertified for misconduct, there's a good chance you can find out some details that way just by going to the council's website and looking up the minutes. Another really useful record from this agency has a super boring name, but it's been really helpful for reporting. It's called the Employee Status Notification Form B. This is just a document that's filled out anytime a police officer has a change in employment status. So that could be retiring, it could be moving to another department for a different job. But it'll also show if that officer has been fired or demoted or resigned during an internal investigation. So that this is an example of what that looks like, and that can just be a really good piece of information to have. Why did this officer leave a department? Was there something sort of sketchy about it or not? Another agency to know about is the Personnel Appeals Board. This is specifically for state employees, so state troopers or Department of Corrections officers. If they're fired and they want to appeal that termination, they go to this board. And the great thing about that is you can request everything that's been filed as part of that proceeding, and those documents will have a lot of details about the officer's conduct. This is a great example that Gilles knows pretty well. A couple years ago, state police fired a trooper named Hayden Wilbur. The ACLU asked state police to provide documentation from their internal investigation. State police refused. It went to court. But in the meantime, this trooper also filed an appeal of his termination with this agency, and the ACLU was able to get those records from the Personnel Appeals Board, which contained a lot of the same information from the internal investigation. And so we were able to write a story kind of cataloging all the misdeeds that got this trooper fired, including illegally searching a civilian's phone without a warrant. And those are records that, again, weren't immediately available from the agency itself, but by going to this other state agency, we were able to get some information. Another thing that's really helpful to know, settlement agreements with public entities in New Hampshire have to be kept for at least 10 years and have to be made available for public inspection on request. So again, if you're covering certain police departments in New Hampshire, it's a good idea to go to those towns and just say, hey, give me any settlement agreements involving the police department for the last 10 years. That'll show you if, they've settled any claims alleging excessive force, illegal searches, racial profiling, anything like that could be reflected in these settlements. And some of these lawsuits don't actually get any media attention until people like my colleague here, Todd Bookman, actually go looking for them and find out some pretty interesting information about misconduct. One final type of record that I'll just mention here, motions to suppress filed in criminal cases. These are when a defense attorney is arguing that the police acted illegally in some way, and therefore the evidence has to be thrown out. That can be an illegal search. It can be a failure to administer a Miranda warning before someone confesses. The thing I like about these, first of all, they're filed publicly in court, so they're pretty accessible. And if you start to see the same officer or department with multiple cases being tossed out of court due to similar issues, that could be a sign that there's, a pattern of behavior there that's worth exploring further. This is something I used quite a bit when I was investigating a state police unit that sort of had a history of questionable vehicle stops, many of which really looked a whole lot like racial profiling. I was able to sort of systematically go through their court cases and find quite a few that had been thrown out due to illegal searches. The final thing I'll say about that is, some of those cases were actually dropped by prosecutors. So this, defense attorney would raise an issue and prosecutors would just drop it without explanation. So I filed a request with the county attorney's office and was really happy to learn that anytime their line prosecutors drop a criminal case, they write a memo to their boss explaining the reasons why. So through that request, I was able to get a bunch of memos where prosecutors were explaining that, this officer in this case conducted an illegal traffic stop and therefore we can't move forward with it. So I was able to quote from those in the story and kind of really add to it. So that's just another example of when, something's not reflected in the public court file, the prosecutor's office, worth doing a right to know request there. That's sort of all I had. I know that was kind of a lot of just information. So if there's any specific records that anyone has questions about or particular stories you want me to talk more about, happy to do that and happy to sort of answer questions offline as well.
Can I piggyback off of, excuse me, one of the things Paul said?
Yeah.
I think Form Bs from the Police Standards and Training Council are an invaluable resource. So as Paul said, those are documents that local police departments are required to send to PSTC when there's a change of status. Listen, most times it's like a good thing, right? Like someone's retiring because they're just moving on, or they've been promoted. But sometimes can be very serious, resigned during an investigation, terminated, etc. I use the Form Bs as a starting point to evaluate whether there are certain police departments or police officers that I should then be going to the police departments seeking information for. Because the Form B is very limited information. You don't know the details of really what's going on with respect to why the officer resigned or was terminated. But it is a good starting point then to then go ask the police department for information concerning what happened. And remember, there's a public interest balancing test involved. And now you have a tool to say there is a public interest in disclosure because you have a document that you could rely on to say this officer was terminated or resigned during an investigation. Because we all need to be mindful when we're making these requests that we may be asked, and I think we need to provide an answer to why is there a public interest. Another series of documents that I would also encourage people to look for, or not look for, is ask police departments are for settlement demands. So you might see a settlement agreement, that's true that municipalities have to keep on file for 10 years. Often it will not necessarily contain a lot of the details or allegations actually of what transpired necessarily. So getting those underlying allegations can sometimes be hard to find where a lawsuit may not have been filed, actually. So then going to the police department and trying to get if there was a settlement demand letter is a step that I've sometimes taken because oftentimes lawyers will be more detailed in their settlement demand about the allegations that are being asserted that were ultimately resolved in a monetary settlement.
I want to thank both of you for taking the time to, give great presentations that are going to be really helpful to a lot of people. So
thank you. And Paul's presentation was amazing, by the way. I haven't really kind of seen in one place like all of the stuff that's available. And it was just, I think that's for journalists in New Hampshire, a tremendous resource. So thank you for putting that together.
Yeah, and as Gilles was getting at, a lot of times these are, it's about using all of these different tools to kind of piece something together. A Form B leads to, hey, I should request the internal personnel files, or a settlement agreement doesn't contain a ton, but leads you to further records. So just, having all of these tools at your disposal can really get you somewhere.
And I would just say people can contact me anytime. You can get my contact information through Emily, obviously. So thank you all very much.